Good morning, everyone. And I think it is quite a distinct pleasure to be moderating this morning's panel in relation to data sovereignty, security, and privacy for local online services. I am joined by a very distinguished panel this morning, and I'd like to introduce them. Mr. Stephen Lee, Chief Executive Officer of Arkitechs Incorporated. Mr. Carlton Samuels, Consultant, Strategy Process, Governance, Assessment, and Turnaround for Accendi Caribbean Limited, Accendi, sorry. Mr. Bartlett Morgan, Senior Associate and Digital Law Lead at Lex Caribbean. And Ms. Amelia Bleeker, Associate Program Management Officer for the UN Economic Commission for Latin America and the Caribbean. Good morning. I just want to put this morning's discussion into context. Over the last decade, digital transformation has been a great priority within most of the Caribbean countries. However, with the advent of COVID-19, it has caused us to place greater priorities, both on a governmental level as well as for the private sector, on moving our businesses online in order to thrive and basically survive. But with it comes many attendant risks and concerns, and they're primarily associated with the matter of data sovereignty, information security, and citizen privacy in terms of what is being done with your information. So I'd like to start today's discussion with an excellent presentation by Mr. Lee, who is going to delve into the architecture of cloud technology and what it means for each of us within the Caribbean. Mr. Lee?
Thank you, Ms. Maharaj. Morning, everyone. Let me get my presentation started. Great. All right, so I want to start by setting the kind of framing what we mean when we talk about the cloud, and how that is relevant to Caribbean data sovereignty, security, privacy. So so what does cloud mean to most of us? We can think about it in terms of Google services, ubiquitous search, ability to find everything, Gmail, photos, ads, YouTube, Wikipedia, which we see as a source of knowledge, Microsoft Office 365 for productivity, IoT and voice control with Amazon Alexa, entertainment, or content services, and these days everyone's favorite incarnation of the cloud, which is our Zoom meetings. All of these things are of course, cloud technologies and cloud services. And I think we all are comfortable in agreeing that we consume all of these things very, very willingly. To most of us as consumers, the cloud means that we have access to technology very widely. Computing is disposable, and by that I mean we want to do something, we download an app. If we don't like that app, we download another app that does the same thing. So it's really easy to get into it and make things happen. And we don't have to do the work of creating those things. The app that we download, it's not our first concern how long it took to build and what it costs to operate it. That's the paradigm of our cloud services. To governments, it's all of those things, because governments generally would have the same kind of considerations and viewpoints as the average consumer. But on top of that, the governments tend to treat the cloud, or think of the cloud, as a platform to engage citizens. This is where we think about getting our passports and paying taxes and so on. And those are things that Caribbean governments have been rolling out over the last almost 2 decades, e-government services. The cloud also allows improved processes and greater efficiencies in a lot of what would otherwise be government bureaucracies. And if we think about the issues and framing of 21st government, which CTU has been leading, we see the movement away from a lot of paper and slow human-based processes into high levels of automation, which are made possible by the cloud and the internet. It's also a way to standardize infrastructure across ministries and so on. So the cloud is of great value to governments, and for the people, the organizations that provide services over the cloud. It allows quick access to the market. Software developers can reach the market without having huge infrastructure to distribute software. A global audience is reachable. The services that we provide can scale and operate really well. So I think we all have this sense of the cloud being this ubiquitous phenomena in our life. It's basically the assumption in the background of everything is that the internet is there, the cloud is there, and we will depend on it and conduct life in that context. So we have this presentation, or the topic we're talking about is clouds in the Caribbean sky. What does that mean for the Caribbean specifically, since what we've just been describing are these services which are generally available across the whole globe. So let's look at what makes the cloud, and what it means when we say clouds in Caribbean, or sometimes I might say the Caribbean cloud, right? So how can there be a Caribbean cloud in the context of all of these global services? So let's just start with this boring definition, which I don't expect you to delve into too much, but there's a standard definition of what cloud computing is from NIST, American Standards Institution. And I'll just read it quickly, and then we'll look at the main points of it. Cloud computing is a model for enabling ubiquitous, ubiquitous, convenient, on-demand network access to a shared pool of computing resources, servers, applications, and so on, that can be rapidly provisioned and released with minimal management effort or service provider interaction. And here are the main points of that. It's on demand, the access is wide, the resources are pooled, and it's elastic, and the services are measured. And I'll give you a really, I think, useful way of thinking about what cloud computing is and what it isn't. You can think about the contrast coming into an organization or hiring somebody in an organization, and IT needs to set up a new email account. And we know what that process looks like. It's sending a ticket to IT, it's waiting on IT's ready, it's all those things. And depending on the IT that we have, that could go in a number of different ways. Versus us getting our Gmail addresses, in which we go to gmail.com, we put in some information, and magically within a minute, we have a new Google address. That second version is basically what the cloud enables. It is it's something that we can all get on demand, and we didn't call anybody to get that that Gmail address. We're able to do it ourselves, and somehow a whole bunch of things worked in the background to make that possible for us. So when we talk about the cloud in that way, or when we say cloud computing or cloud services, we aren't talking simply about having lots of computers. We aren't simply talking about having IT do a set of things. We're talking about the way the internet operates today, in which so many of the services automatically are provisioned, and people have a level of responsiveness. So cloud accelerates business productivity, and it's what we consider the norm. So if we're to just talk about, again, this is what we usually put in front of each other when we say the cloud. We usually literally draw this cloudy thing, and we will connect a whole lot of things to it. And so there's security, and there's Facebook, and there's Google, and there's mobile phones. There's always a mobile phone connected to the cloud. And this is a nice convenient view. But what we want to look at specifically is what does it take to make that convenient view happen? And one of the first things that that we realize, which a lot of us don't necessarily take on immediately, is that the cloud actually means that there are physical locations at which things happen. I'm going to look very quickly at three biggest cloud providers, Google, Amazon, and Microsoft. And we see that they have lots of infrastructure across the whole world. This is the map of the Google infrastructure, picked from inside a Google data center. Lots and lots of computers that it takes to make that Gmail scenario happen. This is Amazon, larger in terms of their reach over the globe, very consistent with the level of services that we get from Amazon. And this is Microsoft. So all of them are large global infrastructure. Took a while to build and get there, and all of this is connected. This is just a submarine cable map of the globe, showing myriad connections all over the world. Usually fiber, which carry data back and forth. And within, so this is undersea fiber, but on land you will have broadband, you will have wireless, we'll have our 4G and so on, internet connecting all of these providers and companies like Netflix to us, the consumers. So that's what the cloud actually redounds to. So we are going to ask, how do we then build the cloud in the Caribbean, and what are some of the data privacy and sovereignty issues? The challenge for Caribbean governments and civil society really is that the cloud services that we spoke about earlier, the Netflix and Microsoft 365, and that we consider normal, they're not anchored in our legal or financial jurisdictions, right? Every time we interact with those services, we're actually interacting with a company which is based somewhere else. Most of the ones that we use in the Western world and the Caribbean are US based. And so the cloud, while it reaches us, it does not necessarily legally and financially, the transactions part of it and so on, is a relationship between us consumers in the Caribbean and businesses in the US. And so if we're looking at the Caribbean cloud, we're talking about the, not so much a paradigm shift, but establishing some of those same service or service opportunities for the transactions and for the who serves up the content and who receives the content to be within a region or a jurisdiction that is more aligned to Caribbean culture, way of life, norm, finances, and so on. To do that, there are a few things which are required, and I'm gonna touch primarily on just the raw technical underpinnings of it and highlight two of the not so technical sides to lead into the rest of the discussions. There has to be connectivity. We saw those maps from Google and Amazon and so on. We have to be able to connect data centers and places where the data content is. There has to be cheap enough or accessible power, electricity, energy. We have to have the space to actually have these data centers. It depends on hardware and software to make it run. There are various systems and software there to help create that automatic Google account. And then the two which I think are really, really key for us. So the first four are can be solved, I guess, if we have the money, the will, and there are things you can purchase to have that. But operations capacity, which is now knowledge and vision on how do we make this happen. And finally, services which are aligned to what we need in the Caribbean. Just looking quickly on the first four, this is the connectivity in the Caribbean. So zooming into the Caribbean, and we see that we are well connected. So having connectivity between countries and internationally is not a problem that the Caribbean has in terms of the absence of infrastructure. The cost of infrastructure and so on is another matter, but we're well connected. These are just some snapshots of internet exchange points that have been built up over the years in the Caribbean, in Grenada, in St. Lucia, in Dominica. Internet exchange points have been popping up, and these are like a crucial part of actually giving those points of presence and connectivity. And you'll note that the IXPs in our region look a little different from that Google data center because we're operating at a different scale. I'll mention this company, Cloud Carib, not as an endorsement, but just to give an idea, and we can check out their the facilities that are provided as one of the few providers in the region that are moving towards locating cloud services in locations which are actually in the Caribbean or and Latin American jurisdiction. And so you could see here a similar map of points of presence being built out gradually. And just to look at what's happening across the region, as far as these cloud services are exist, we have a number of internet exchange points that have been brought up, operating at different levels. There are commercial data centers which offer cloud services. I mentioned Cloud Carib. There's a significant data center in Curacao, Blue Nap Americas. Fujitsu operates in Trinidad, and then we have a lot of small and medium enterprise who provide private data center services. Our telecom service providers in the region, most notably Flow and Digicel, they do, because of the services that are provided regionally, have to have this kind of infrastructure in place as well. And then I would classify, there are some private operators of data center services. Our Caribbean governments, they all have data centers. They do provide public services, but I'm thinking of the facilities there are primarily for government consumption. Financial institutions, education institutions, all operate some level of cloud services. And what we are talking about is amping up those kinds of services at a level in which we can have a similar experience as we did with Google. To do that, just to end with these two sets of considerations, for service providers, they have to be able to find and develop regional and local expertise to operate these things. So our engineering, IT capacity has to be able to move to this. The cost of the infrastructure, especially when we're moving beyond one data center in one location or just one rack of servers, the cost of that infrastructure has to be dealt with. The business model of what we're going to sell at what cost, and then there's the enabling environment, and I think we'll be talking a little bit about that this morning. Legal issues around having these services operate. Consumers, and I think this is where I'll lump inside of this, government, civil society, and so on. It's very convenient for us to consume the Google services, but we have to understand the cost of establishing those, the time it took, and the scale at which it operates. And so we ask ourselves inside the region, what level of services are we willing are we asking for? What level of automation, what level of scale are we going to go for if we want to have similar services inside the region? And these things are there's no answer. I won't attempt to answer it this morning, but these are issues that are being considered at the regional level. And I'll leave it at this and end here.
Thank you for that very erudite presentation. And I know that you had ended with mentioning that, one of the things that consumers need to take into consideration are the legal concerns associated with regard to the use of cloud infrastructure and technology. And I think it's a wonderful segue leading to our next presentation by Mr. Bartlett Morgan in conjunction with Mr. Carlton Samuels.
Thank you, Vashti. Hello, everyone. Thank you to the organizers for having Carlton and myself again. Now, our task this morning, as I understand it, is to get a lawyer and a legal consultant to be short and spicy. I don't know if that's possible, but we'll see how far we can go with that. Now, in essence, well, let me just back up things a bit. In essence, our job is sort of a continuing one. Over the years, we've sort of jumped in to provide a bird's eye view of what has been happening and what the developments are in the region and globally as regards data privacy, because it's sort of something, it's become recently something of an ongoing concern for us in the region. And so this morning, that is essentially what we're doing again, albeit in the context of the heady conversations that are now afoot in the region and globally around issues of data sovereignty and data localization and, you know, pushing towards regional cloud services and that kind of a thing. The sort of issues that Stephen would have touched on in his presentation. And so essentially what we've done is we've broken down what we want to touch on at a high level today in our short and spicy presentation into essentially the global trends and highlights over the past year since the last time we met. What are the regional sort of trends and highlights that I think we should be mindful of? And then finally, what are the considerations that we should have in mind within the Caribbean going forward? What are the things that we need to be tackling next? And so first up, global trends. So I've started here with a map, and this is a map from DLA Piper, a global law firm, and they tend to track privacy laws, and they provided this very, I think, useful visual to give you a sense of where we are in the world today. Now, I've twinned that with some research from an academic out of Australia, Mr. Greenleaf, who has given his last report that says that as it stands right now, there are essentially 132 laws, privacy laws, different countries with privacy laws in the world, 132, which is a significant improvement over prior years, you know, before 2019 and so on. And that in addition, there are 27 different jurisdictions with bills that have been, for example, tabled before the parliaments, that kind of a thing. And so it gives you some context that essentially there is a sort of onward march as regards data privacy. And that has certain implications, certainly, you know, for issues around the cloud and so on. Now I put asterisks beside the data because when this data was collected and published, since then, a number of other jurisdictions have passed laws. And so, I mean, the specifics don't matter as much as the conclusion which can be drawn is that we're marching on at this point. And data privacy is no longer sort of an abstract nicety, but no more or less a sort of necessary consideration, even from a business perspective. When you're looking to do business, a lot of these cloud service providers will now have to give consideration to a lot of these issues as you look to move into the Caribbean and set up shop, as it were, or to process the data of persons from within the Caribbean, that kind of a thing. Now, global big picture observations. A lot of the are passing or have recently passed data privacy laws, as we've mentioned before. And in addition, what they're doing now is they're also operationalizing it. And by that, I mean, they're, for example, passing regulations that will go to the specifics of who, what, where, when, and why of actually complying. And so there are all the examples. There's Brazil, which was in the news up to literally yesterday, where they are back and forth on exactly when the law should come into play. There's China, who recently, maybe about a month ago, they've tabled a comprehensive data privacy law, which is an interesting turn because typically the approach they've taken in China towards cybersecurity and data privacy is to have very either sector-specific or, well, generally sector-specific type laws. And so now for the first time, they're passing a comprehensive data privacy, data security type law. There's obviously California there, which has been in the news at least for the past 2 years as well, because they have also operationalized their law with regulations, and they've even started enforcing their CCPA. And then also there's India and Nigeria, who've also tabled laws and are looking to pass within the next year. Now, the other trend that we've seen is that, and this is a continuation of a trend that we've identified from last year, which is fines, fines, fines. The regulators have more or less signaled that essentially it's no longer playtime. And so with reference to Europe, which is where these statistics refer to, you've seen that essentially there have been over 347 fines already. And keep in mind that the GDPR, which is the European law, entered into force in May 2018. So just over 2 years, already 347 fines, the largest of which we would have mentioned last year, which is that 50 million euro fine for Google that was issued by the French regulator. And so we know that if you don't get it right, there are consequences if you're looking to process personal data. And again, obviously this applies in the context of the dreams we may have within the region. And well, not dreams, that makes it sound fanciful, but certainly the objectives we may have about cloud computing and bringing that kind of processing power to bear locally and what have you. And we'll get to that later. Now, the other thing that we've noticed is more and more countries signing on at the level of country to country to various essentially international conventions and agreements to do with certain standards and safeguards that each country will agree to put into place to allow for international data flows and the free flow of international data. Now, obviously the Europeans, well, I should say the Council of Europe, are some of the primary persons behind this kind of move, because Convention 108, which has been around since the 80s, it's recently been revamped and revitalized, sort of, refresh it for the modern era. And so we now refer to it as Convention 108 Plus. So it's essentially a protocol to the original convention. And essentially that protocol will go into effect by around maybe 2023. But if they get, I think, about 38 signatories before then it will automatically go into effect. And so essentially we're seeing more and more jurisdictions signing on to this, and this may have implications for us in the Caribbean, but I won't get into that right now. Perhaps we can deal with that in the questions after. Now, the other big fish thing that you can't speak about data privacy today without speaking about is a decision that was issued out of Europe's highest court about a month or so ago, and it's popularly referred to as the Schrems II decision. Now, we can get to the details, but essentially all it came down to is this. There was a privacy agreement between the United States and Europe about international data transfers. And essentially, that agreement was struck down by Europe's highest court. Their reason was essentially that it doesn't provide enough safeguards, which is a word you need to keep in mind nowadays, in the context of international data transfers and data localization and so on. Safeguards. It didn't provide enough safeguards. We didn't feel that Europeans' data privacy rights were being protected when their data was being transferred to the United States to be processed, by a lot of these entities, and therefore they struck down the agreement. But what they've also said, which has, I think, more direct bearings or implications for us in the region, is that there are other methods of putting safeguards in place to allow international data transfers. And in particular, they reference the standard contractual clause, which is entered into at the individual level between entities, where you agree to transfer data once certain measures are put in place on your end as the receiving party. And so that is what I think has the most sort of implications for us in the region as we think about our international partners and doing business going forward, especially in Europe, that we now need to have these kinds of arrangements in place if we're looking to do that kind of a thing, because, well, there's no, at the moment, international agreement in place, for example, between Europe and CARICOM that would allow us to just freely send data back and forth, that kind of a thing. Now, the other big fish issue, which it's kind of gone under the radar for the past few years, and thankfully we picked up on it at this year's IGF, is the whole issue of data localization and related to that data sovereignty. So essentially what I've put up here are countries that have very targeted data localization laws. And as you can see, it's not a huge list. And I should perhaps put an asterisk there, because it very often depends on what you define data localization as. Because if you define it in the broadest sense, without the hysteria, it really is just any kind of law or requirement for data to be kept local, unless there's an exception. And if you use that broad definition, then strictly speaking, most of the privacy laws in the Caribbean have a data localization element, because they say you have to keep the data in that Caribbean jurisdiction unless you meet an exception. And so it depends on how you think about it. I think what happens is that very often when people say data localization, what we really mean is data sovereignty, which is an express requirement of governments that certain categories of data generally cannot leave the jurisdiction, or even if it leaves the jurisdiction, a copy must be retained within the jurisdiction on servers within the jurisdiction and so on. And so for us in the Caribbean, the consideration therefore becomes, if we are looking at data sovereignty as an avenue that we want to pursue for whatever policy ends, it's not for me to decide or even think about that. You know, it's up to each country to decide their own path. But if this is a path that we are looking to go down, then we need to sort of be mindful of what kind of framework do we put in place to ensure that, well, yes, you protect the data that you consider important to your jurisdiction. Perhaps, you know, you don't want it to go to a jurisdiction where the prying eyes of that government and their laws will allow them to sort of lift up the skirt, so to speak, and peek at your data of your citizens, that kind of a thing, which is, for example, the rationale that Russia has used when it passed its data localization laws, that social media entities, they should keep it there in Russia because following, I mean, what happened around, I can't remember the name of the guy who worked with the NSA, and he provided lots of disclosure about what the American government was doing with data, you know, from these social media entities and what have you. And so following from that, they said, well, no, we don't want that. Keep our data here. So that being the case, I don't want to sort of stay too long on that because time is of the essence. So for the Caribbean, what is our latest update? So as it stands right now in the region, and when you define Caribbean in the broadest sense, you get up to 32 jurisdictions in the very broadest sense. In other words, all the islands that are physically within the bounds of the Caribbean Sea, as well as those mainland entities that have a strong enough continuing cultural, historical, political connection with those Caribbean jurisdictions. So for example, obviously Guyana, Belize, Suriname, and so on. And so with that broad definition, of all the countries in the Caribbean, essentially 18 have privacy laws and 14 are without. Now, this is an improvement from the last time we met. And if you look on the sort of a chart there in the bottom left, you'll sort of essentially see how the laws and the rate at which laws have been passed over the different years. And so there's more or less been continuous action from 2016 to the present, where at least one law has been passed every year in a jurisdiction. And obviously the message is we are sort of in tandem with the global direction of passing laws in more and more jurisdictions. Now, time is against me, and so I want to push on really quickly just to identify the two jurisdictions there that have passed laws since we last met last year. That's Jamaica and Barbados. Since then, BVI has formally tabled their privacy law, and then there's also enforcement action. We've seen enforcement action out of the Cayman Islands in the past, well, few weeks. So there's a lot of activity there. And on that note, I just want to hand over to Carlton really quickly to discuss some of the considerations for the future.
Okay, thank you, Bartlett. Morning, everybody. It is going to be very, very quick because we want to move along. There are a couple of considerations. Now that we have laws on the books, we have to operationalize the laws. And in very many places, it's been the case. We've had cases where laws have existed from as early as 2004 without being operationalized. In our jurisdiction, the operationalization of the laws happen when you pass regulations, secondary legislation. These are really very necessary to operationalize the laws. And there's a big issue with funding for the regulators. If you look at the laws that are passed and you go through them in detail, you see that they have been data commissions and the commission authorities, but there is no methodology expressed about how you fund it. And in this case,
Carlton, Nigel, Casimir, if I might interrupt you for a second. I don't know if your microphone is moving, it might be on your head, but we're getting some interference in the audio, some noise, like background noise, you know, like...
Maybe it's the fan, Nigel.
It's a fan. Ah, okay.
So
much clearer now. Much clearer now. Yes.
Turn it off a little bit.
Okay.
So we have a situation with funding for the regulators. So we have a regulatory framework that is kind of teased out in the law, and then we have to instantiate the framework with the regulations, and then we have to figure out how we're going to fund the regulators. That is something that is going to need some attention and going forward. Talking about the regulations, one of the things that the recent goings on in the space is the regulations for the California Consumer Protection Act. If you look at that regulation, the set of regulations that come, this is the only one that is really the GDPR type regulations on this side of the world, and it could provide some kind of framework that could inform what we do here in the Caribbean. It is not quite as dependent on the fines that you see the European regulators implement. There's some moral suasion that is involved with their regulations, but I think that would be some kind of framework for us to look at. So all in all, it's a good, we're in a good place. We still have some work to do, and I would expect that when next year we talk about this, if we do, then we will see some progress, especially in the deployment of the regulations. And this is where we end and take some questions. Thank you.
Thank you both to Bartlett and Carlton for the short, spicy, and breezy presentation. It was quite intriguing and a wealth of knowledge. And it's good that you have provided an overall bird's-eye perspective of where we're at with our legislation within the Caribbean region. And it's a very good bridge that leads us to Amelia's presentation, which goes in depth into the analysis of some of our legislation. And I'll just hand it over to you at this time. Thank you. Amelia, you may need to unmute.
Yes.
Thank you. Sorry about that. I'm just going to put up my PowerPoint. Good morning, everybody, and thank you to Vashti for the introduction. My name is Amelia Bleeker, and I am an Associate Program Management Officer at the Economic Commission for Latin America and the Caribbean, based at the sub-regional headquarters for the Caribbean here in Port of Spain. So this morning, I'm going to introduce you to some recent research of UNECLAC on 6 data protection pieces of legislation in the Caribbean region. So what we did was we undertook a review of the data protection laws of Antigua and Barbuda, Belize, the Bahamas, Barbados, Cayman Islands, and Jamaica's law, which has just been enacted in the last couple of months, to assess their alignment with the European Union's General Data Protection Regulation, which has just been introduced to you all by Mr. Bartlett. So it is indeed good to come straight after Mr. Bartlett, because he's introduced a lot of my presentation. So where there's some overlap, I'll spend more time in other parts. But let's crack on. So the aim of this study was to assist countries to put in place legislation that facilitates data protection and sharing and promotes the aims of protecting privacy and personal data while creating an enabling environment for digital government in the Caribbean. So before I take you to the findings of the country reviews, I'm just going to go through some of the background to the study very quickly. And then we'll also introduce some important aspects of the GDPR. And yes, then we'll finish with the country findings. So The rationale for the study was, well, there were a few rationales really. So the first was an observation that many Caribbean countries are currently trying to put in place effective systems of e-government. And to implement digital government or e-government, it's very important to have in place an enabling environment. And part of that is modern legislative and regulatory framework for data protection and sharing. And obviously also to promote privacy rights. So the right to privacy and the protection of personal data have taken on greater significance in the digital age, with technological developments increasing government surveillance capabilities. Mr. Bartlett referenced the Snowden revelations that took place in the United States in 2013. So that's a prominent example. And also technologies that allow private organizations to conduct targeted advertising and profiling. So for example, the use of real-time bidding, which is a technology used by social media services, whereby users' data, sometimes very sensitive personal data, is sold to advertisers for advertising purposes across other websites. So this is what happens when you, for example, click on an advertisement for running shoes on Facebook, and then suddenly, no matter what website you use, you're also getting adverts for running shoes popping up in your face. So that's real-time bidding. And these kinds of technologies have real privacy implications, and therefore they must be met with strong data protection frameworks. So e-government presents vast opportunities for improving public service delivery and governance outcomes in Caribbean countries. It can save individuals and governments time and money, reduce the potential for corruption, and minimize the impact of distance between islands and countries. So, so with this study, it is the aim that we would want to assist countries throughout the region to put in place strong, modern frameworks for both data protection and data sharing. So this is one of the slides that I'll just go over quickly because Mr. Bartlett has already talked about the data protection frameworks. And
you didn't share yet, Amelia.
Sorry?
You haven't shared the slides yet if you were planning to.
Ah.
Share screen.
Thank you, Nigel. I thought I already had. All right, sorry about that, everybody. We're back on track. So, yes. So as I was saying, Mr. Bartlett has already talked about the data protection and sharing frameworks that are already in place in the Caribbean. And actually, the study which will be published, UNECLAC study, which will be published in about a month, sets out these laws in a table. So there's an overview of that in the study. But as we'd already said that the data protection regimes in the Caribbean are in varying stages of development. Several countries have no relevant laws in place. Other laws require revision for consistency with modern data protection and sharing principles. So what I'm going to do now is highlight some of the key features of the European Union's GDPR, because the GDPR was the benchmark that we used to assess the alignment, to assess the 6 Caribbean data protection laws under review. This regulation has become recognized as the golden standard for data protection around the globe. And of course, the reason that it is so relevant to the Caribbean region is its extraterritorial scope. So what this means is that not only does the GDPR apply to EU member states processing personal data, it also applies to Caribbean organizations where they are processing the personal data of EU citizens. So this is what gives the GDPR import into the Caribbean region and other parts of the world, I should add. But it's an 80-page regulation, and I'm not going to go into every all of its key features, but I would want to highlight two that are particularly important for our discussion today. So the first is restrictions on international transfers. So under the GDPR, cross-border transfers of data are only allowed from the EU if the recipient country provides an essentially equivalent or comparable level of protection for personal data. And Mr. Bartlett, he introduced the EU-US Privacy Shield, which was a major agreement facilitating cross-border data flows between the EU and the US. But under the GDPR, there are various possibilities for facilitating secure cross-border data flows. This is important because Caribbean governments and Caribbean individuals and businesses transfer massive amounts of personal data across borders each day. These cross-border data flows carry significant economic value, and they also allow the Caribbean to engage in international trade with major trading partners in the US and the EU. So when countries are putting in place modern data protection legislation that is aligned with the GDPR, this enables data controllers operating out of that country to facilitate, to carry out cross-border data flows in ways allowed by that legislation. And then another one, since the focus of today's discussion is on Caribbean online service providers, I also wanted to highlight a key requirement on data controllers under the GDPR, which is to implement data protection by design and default. So what this means is that the GDPR requires you to integrate data protection concerns into every aspect of your data processing activities. And so this is a key element of the GDPR's risk-based approach. And it ultimately requires you to ensure that privacy and data protection issues are considered from the design stage of business practices and activities right through the life cycle. And to implement data protection by design and default, you may need to review your business processes and procedures, develop new IT systems that embed data protection by design, develop organizational policies with data protection in mind, and design your business processes in a way that ensures that you only process personal data that is necessary to achieve your specific purposes. And this can all sound quite frightening for organizations, especially small operations that only, have between a few to 10 employees. There obviously will be associated time and cost with putting these measures in place, but they will also enable Caribbean organizations to avoid fines and other compliance penalties, both under the GDPR and any local data protection law that's in place. And importantly, it also would enable Caribbean organizations to engage in e-commerce and digital trade beyond local markets. So now let me introduce you to the provisional findings of UNECLAC study. So as I said, we looked at the data protection laws of 6 Caribbean countries, Antigua and Barbuda, Belize, the Bahamas, Barbados, Cayman Islands, and Jamaica. So what we found is that none of the laws were fully aligned with all elements of the GDPR. However, all of the laws had one or more areas of substantial and partial alignment. And then 3 of the laws, actually the most recently enacted ones, and this makes sense, which I'll go on to explain why shortly. So they had at least one area of full alignment and several areas of substantial alignment. So it should also be noted that all laws except one had at least one area of non-alignment. A quick point that I want to make before I go on to the next slide is, although it is obviously ideal for an area of the data protection law to be fully aligned with the GDPR, in many cases, substantial or partial alignment will be sufficient for achieving a comparable level of protection with EU law. And if this is, of course, the aim, should be the aim of Caribbean countries looking to put data protection legislation in place. It's not that you need to match every provision of the GDPR word for word or provision by provision. What the European Commission has said, and the case law of European courts, is that countries should be aiming to put in an essentially equivalent or comparable level of data protection standards. So this is what we're aiming for, and should be kept in mind as we go through these findings. So, so as you can see here, there are 3 countries that are more fully and substantially aligned with each element of the GDPR. And it's no coincidence that these are, in fact, the 3 laws that were most recently enacted, because, of course, the legislative drafters in those countries had the benefit of drafting the legislation in light of the GDPR's requirements. As Mr. Bartlett told us, the GDPR came into force in 2018, and Barbados's law came into effect last year. The Cayman Islands legislation dates to 2017, but the draft of the GDPR was already around at that stage. So that country had the benefit of looking at it when it was drafting its legislation. And then Jamaica's legislation has just passed the House in Jamaica in the last few months. So these 3 laws, Barbados in particular has many areas of full alignment, so it sets a really fine example for other Caribbean countries looking to put data protection legislation in place. And then the other 3 laws that we looked at, so Belize's data protection bill, so that was never actually enacted, it was still at the bill stage. It dated back to 2014. Antigua and Barbuda's legislation dates to 2013, and the Bahamas legislation dates to 2003. So particularly in the case of the Bahamas, this was enacted almost 20 years before the GDPR came into existence. So it obviously did not have the benefit of being drafted in light of that. And some of the modern data protection mechanisms and standards that we would like to see in legislation are just completely absent. But there's been a rapid development of data protection frameworks over the past 10 years, 20, but even more so in the last 10 years, in light of the increased importance we are now attaching to the right to privacy, since we've seen that individuals, they just don't have as much control over their personal data anymore in light of technological developments. And there's also been some very serious data protection breaches that have underlined the importance of enacting modern data protection frameworks. So those are the provisional findings of the study, and they are set out in much more detail in UNECLAC's study, which we published in about a month. But I will leave those there and just finish with some quick points on why, how Caribbean organizations stand to benefit from GDPR compliance. So one of the first ones is obviously gaining the trust of customers through securing their personal data and ensuring data privacy. And then also at the forefront of a lot of businesses will also be avoiding financial penalties under the GDPR. So we're yet to see any Caribbean organizations being levied with penalties under the GDPR. But I should add that some global organizations operating in the Caribbean have been the subject of fines. So for example, Google, as we've just heard in the previous presentation. So I think it'll be a while before we'll see GDPR penalties in the Caribbean, but it is on the horizon. And as countries seek to put in place their own data protection frameworks, then penalties will also be possible under local laws. Then, of course, data breaches are very costly for companies, so reducing the risk of data breaches can attract investors and create competitive advantage. And then one of the key ones, in my view at least, is facilitating secure cross-border data flows with major trading partners, including in the EU and the US, and the significant economic value that goes along with facilitating that international trade. So thank you for your attention, and I'll stick around for any questions towards the end.
Thank you very much, Amelia, for a very wonderfully comprehensive and insightful presentation. And even though we missed like the first slide, the rest of it was pretty spectacular. Now, the contents of the presentations this morning, I must say, have been very, very, very rich. And as a result of which, we do have some questions that were submitted at the Q&A. One of them in particular relates to the last presentation that was presented, and also that of Bartlett's and Carlton's. So I will start with that. This question is posted by Rishi Maharaj. What impact would the recent Schrems II ruling have on Caribbean businesses, say financial and tourism sectors, that have collected EU personal data and process it in the US via cloud services? So I'm presenting this to the panel. Anyone can take it at this time. This is also pertinent to you, Mr. Lee, given what you've outlined. So who'd like to go first? Don't rush all at the same time.
I mean, I'll have at it. So here's what I would say. If the question is what impact does Schrems II have on the Caribbean, you could argue perhaps a bit facetiously that it has no impact, because the big impact of Schrems II was to strike down an arrangement between the US and the European Union. And to the extent that we don't, for example, have an equivalent arrangement already in place where we could say, well, if theirs was deemed to be inadequate, then perhaps ours might be too, then it doesn't change much, because as it stands, you'd have heard Amelia speak to the fact that there are a number of other mechanisms for ensuring international data transfers between jurisdictions, and especially private parties between jurisdictions, between Europe and the Caribbean, for example. And so to the extent that the ruling didn't, for example, go further to say all these other mechanisms are also inadequate, for instance, then it really means that the state of play as we knew it, vis-a-vis the GDPR and international data transfers, with the Caribbean, it stands. And so essentially, Caribbean businesses need to ensure that they continue to do the things that they perhaps, well, I would hope that they would have been advised to do from before, which is to ensure that you have some kind of adequate mechanism in place to transfer the data between the Caribbean and Europe. Whether that's, some kind of standard contractual clause, or you had consent, or it's necessary for the nature of the data being processed, that kind of a thing. Make sure that there's some lawful basis in place.
And I would just add that I think one of the interesting things to have come out of this judgment is for Caribbean organizations is, so of course the Caribbean's two major trading partners are the US and EU countries, but it's very confusing for Caribbean organizations to wonder, if I'm compliant with the GDPR, does that mean I'm also compliant with US law and vice versa? So what this decision tells us is that while compliance with the GDPR will in most cases satisfy the requirements of US law, the reverse is not necessarily true. And I think Carlton mentioned California's new privacy law, and that is a very strong data protection law that is becoming the standard of business across the United States. And it is very closely aligned with the GDPR. But until that law is in effect across US states, there will be no uniform data protection standards in the US. And so it's a bit of a complicated picture for Caribbean businesses looking to do business with US with data security measures in place.
Yes, because Carlton here, Amelia pointed out something that was very significant. What we have to depend on now is what they call the standard contract clauses, SCCs, because there's no uniform way to be in compliance. We have to go case by case, and the standard contract clause is a methodology. By the way, Shem 2 actually endorsed SCC in its use. So that is the only way we can make sure that we're in compliance.
Do we have any other contributions before we move on to a similar related question? And all 3, 4 of you raised it. And that would have been, Amelia had mentioned the matter of targeted profiling by social media. And that is done by private sector companies for and it involves real-time bidding for advertisement purposes. And we had also mentioned the issue of surveillance and privacy, particularly within a cloud context. But even the governments internationally, one of the issues that have been raised is their legitimacy of undertaking surveillance activities during COVID. So you find that there has been a lot of discussion within the international sphere about data privacy and the right of both public and private sector agencies to undertake surveillance with regard to your own information without your consent. And how do you think this impacts on the average Caribbean citizen? And what should be their concerns and what protections need to be put in place?
So there's some interesting dynamics at play here. So obviously, the sharing of health data during the COVID-19 pandemic has been crucial in fighting the virus. But then on the other hand, we also want data to be shared in a way that respects data protection principles. And some particular technologies have been developed in light of COVID-19 to fight the virus. And one of those is contact tracing applications to trace human to human contact and carry out proximity analysis. And so many countries are using these applications, and in some cases they're being developed with pretty questionable privacy policies. And for example, I think there's an app being used in Guatemala, and it enables the data to be kept for up to 10 years, which is well beyond hopefully well beyond the life cycle of the virus and pandemic. And there's also concerns that the data would be used for other purposes to which the data subjects have not consented. So while technology can be very important in fighting the COVID-19 virus, it's also important that data protection frameworks are in place to ensure that this is done in a way that respects the right to privacy.
Any Bartlett or Carlton or Stephen?
Yeah, can I make a...
Go ahead, Carlton.
Thank you. Can I just make a small contribution there on Amelia? The question of the use of the data, especially COVID-19, one of the aspects that are now that is now in play is that how we might use the technology to ameliorate the security and the privacy aspects. And this is where they've been talking about blockchain technology in helping move this along. They're right now, the World Health Organization and a couple of other stakeholders are looking at blockchain implementations that could inure to greater security and privacy on the data that is collected, health data. But they're calling it biosecurity data now, we see. And this is where I think it's going to go in a little while. Just something that you might need to watch.
And just to add to that, I think this is something that governments, regulators, let's call it the aspect of our civil societies that are concerned with the future and leadership will have to treat with directly or think about, because just from the view on the ground, what I've seen, the average consumer, the average small business and so on isn't thinking first and foremost about those things. A lot of our businesses and consumers are looking at, can I access the service? Is it low cost to me? And the fact that the service might be, you're paying for it with loss of privacy and so on is not really top of mind. I think it becomes something that surprises the average consumer when we see large, significant uses of their private data when we have things like the Brexit vote and US 2016 elections and so on. People suddenly realize, oh, so this question I answered over here was aggregated and created a pattern which was used to shape my opinions and so on. But in the moment by moment clicking on an ad or so on, it's not something that the average person thinks about. So I think this is where our leadership would have to look into the future and say, what's the cost of operating the services in our jurisdictions?
On the matter of data stewardship and the government being held to a different standard vis-a-vis the private sector, I do have a question that was posted by Mr. Rodney Taylor, and it is to the panel: are governments held to the same level of accountability as private entities in relation to the handling of citizen data? With the deployment of interoperability frameworks to facilitate data sharing across platforms and government, does the government then have a free hand to share between ministries, departments, agencies to facilitate seamless public services? It's a very good question. Would you like to address this?
Yeah, I can, I'll start and then you can add your thoughts about the panelists. So where a country has a modern data protection framework in place, and as we've seen, this is not all Caribbean countries. Countries have various, are at various stages of developing their data protection legislation. But once a piece of modern data protection legislation is in place, it would apply to all data controllers equally. So that's both private sector and public sector data controllers. And that means that a government, even when it's sharing within an organization or across ministries, it would need to identify a lawful basis for sharing that personal data. And it's not just that it could, share it around ministries willy-nilly. It would have to observe the conditions for lawful processing under that piece of legislation.
Carlton or Bartlett?
Yeah, so the truth is when a question like that is posed, I think in the Caribbean context, it really comes down to, and I guess this is really a lawyer's answer, but it really does depend. It depends on the jurisdiction. It depends on whether or not they have some kind of a meaningful data privacy regime in place, as Amelia mentioned. It depends on whether or not, for example, they've passed the law, but it's not in effect. And so effectively it's a no man's land. And all of those factors have to, tie into your response, when you speak about it. But speaking at a broad level, here's what I would say, and this probably even ties back to the prior question. I feel like a lot of what's going on now in terms of government's use of data, stuff, around COVID tracing apps and so on, it's sort of a kind of almost want to say it's an inflection point for us in the Caribbean, where we get an opportunity to determine how much we trust our governments. Because in situations where you have sort of a legislative no man's land, as is the case in quite a few jurisdictions still, then the question is, well, what will my government do with my data when they have a free hand? Are they going to essentially not abide by well-established, accepted principles around data privacy and so on? Are they going to do the right thing, so to speak, or not? And so this really, I think, ties into a larger conversation around trust. Because one of the things, I remember even back in the day before data privacy laws themselves were being passed, one of the things we very often say to clients and so on is, well, the value of doing the right thing is the trust it builds with the persons whose data you're processing. So regardless of whether or not a law is there is that sort of, I think, unspoken soft requirement to ensure that you operate in a manner that doesn't breach the trust that your citizens and your residents have in you as a government. Because if you break that trust, then they're not likely to, for example, want to take up all these different fancy services that we're rolling out. Yesterday, we spoke a lot about digitization and the different governments making a push towards that. If there is no trust in a particular government and how it operates, people are not going to voluntarily want to take up services that they don't have to take up without that trust. So I sort of stretched away from the original question, but I thought it was important to kind of make that connection.
In fact, I'd put in my 2 cents as the person from the government here. It is a balancing exercise, and you are right. It's a balancing exercise that is important to continue to maintain citizen trust and confidence in providing your data to the government, because you have to balance protection of citizens in most, if not all, of the jurisdictions' constitutional right to privacy, and also the state needing data, like for example, with regard to biosecurity data and how it is used, and ensuring that it is used for the purpose for which it was provided and handled and secured adequately. I just, on the context of adequacy, before I get into the real technical questions from Mr. Lee, I would like to ask you, both Bartlett, Carlton, and Amelia, given your understanding of where we're at in the Caribbean with our legislative frameworks, do you think that any of us are anywhere near to obtaining an adequacy decision or approaching a decision of adequacy by the EU? And what would be the benefit to the CARICOM or any Caribbean country in so doing?
I can start on that one. So, so far, the European Commission has issued, I think, 22 adequacy decisions, and it's a fairly long, complicated process because it involves a lot of back and forth with the European Commission on the data protection standards, but also procedural guarantees that a country has in place. While as yet there are no Caribbean countries that have received an adequacy decision from the European Commission, there are a number of small island territories that have. I think Jersey, Isle of Man, some of the UK's dependencies have received adequacy decisions. So that may be encouraging to Caribbean countries to know that other small jurisdictions have received these decisions. The reason they're so important and why countries should, strive to move in the direction of maybe one day applying for an adequacy decision is they essentially they're a general authority for the flow of data between the country that gets the decision and EU member countries. So it means that in the case of individual cross-border data flow, it doesn't need to be considered on a case-by-case basis. What mechanism are we using in this instance to ensure data security? There's this general authority, so it's a very useful tool for a country, and it also would have significant economic value. I think that's probably enough. If you have anything to add, Bartlett and Carlton.
So yes, you laid it out quite nicely there, Amelia. The real objective is that we have a framework, comprehensive framework with an adequacy decision that allows the interactions to go on without having individual contracts, standard contracts, and so on. The triage to get to the adequacy decision is very detailed. They go and look through to make sure that all of the principles of data protection are involved in the legislation. They look at the regulations and the procedural issues surrounding. One of the big ones, for example, is that if a citizen wants to make a claim, how many hoops they have to jump through to get access to the commissioner or the persons that are involved in adjudicating the claim. That one seems to mess up a lot of people. If you look at what happened with Guernsey and the Cayman Islands, for example, has been trying to get through that adequacy decision. I don't know about it. Have they gotten it yet? They were going through it.
Not yet. Not yet.
No.
Yeah. So these are the real issues that you look. So it also forces, the good thing that comes out of the adequacy decision, it forces you to look comprehensively at the law and the regulation to ensure that you tick all the boxes to get the adequacy decision. So in my view, just asking for an opportunity to get the decision enables the kind of review that will make the law and the regulation and the framework much stronger.
Yeah, and I would also add it's quite a dynamic process. And the European Commission isn't just looking to tick boxes. It'll also work with the country to improve their systems or frameworks as they go along. So as Carlton just pointed out, there's a lot of benefit to even just engaging in the process, even if it doesn't immediately result in an adequacy decision. And now that we're seeing some very strong pieces of data protection legislation in the Caribbean, including Barbados, Cayman Islands, and Jamaica, it would be interesting to see in the coming years if one of these countries does apply for an adequacy decision, and other countries can get an insight into that process. Yeah,
I'd like to jump in to endorse in large part what has been said by the other contributors already on the adequacy issue. What I want to add is that it goes often beyond simply just, do you have a fancy privacy law? They also look at big picture issues like, what is your approach to human rights in your country? Are there actual, privacy related decisions being issued by a regulator already? Practical things as well. One of the other things that people don't often talk about, but which often is considered, though it's not mandatory, it's very often considered, well, certainly, or it will be considered in the context of the GDPR, is whether, for instance, your country has acceded to or ratified Convention 108. It's spoken about, but if you go back and read through the recitals in the GDPR, they actually subtly kind of hint you in that direction. And so that, to my mind, is also another sort of launching, I think, point for other bigger conversations that we've started in the Caribbean area about, well, what is the approach to data privacy going forward as a collective region? What should we be thinking about? And, actually, Carlton and I were having a conversation about this recently, which is perhaps we might need to forego where we've had conversations in the past where we go, well, as a region, we should have our own kind of treaty that treats the privacy and kind of make the entire region sort of, kind of like our own bubble or cloud, so to speak, where, transfers between jurisdictions are fine and what have you. Perhaps we might even consider foregoing that kind of a direction and consider simply just acceding to Convention 108. Because essentially, to the extent that we've already started making the push, we've already started the push in the region towards passing privacy laws, it means then that acceding to Convention 108 would not be something that's something like an additional hurdle that we haven't already contemplated in terms of resources and what have you. And then there's the added benefit that it makes it easier, assuming all the other factors are in place, decent human rights record, adequate privacy law, to get that adequacy decision from the European Union.
One final point before we move on to the next question. Bartlett's comment reminded me that the European Commission has a document called the Adequacy Referential. And this is a short, very good document that just outlines the basic concepts and procedural aspects that you would require in your legal system beyond just a fancy data protection law to work towards an adequacy decision. So it's called the Adequacy Referential, and it's available online. It's, I think, less than 10 pages, so it's a good piece of short guidance.
This is an actual very excellent and pointed issue that many Caribbean governments are considering at this time as we contemplate how to move ahead with digital transformation and also building that legislative framework. But it's not just a beautiful piece of law in the books, it's the operationalization and the ultimate impact on just our own country, but what happens with our cross-border data flows and our interactions with international players, given the fact that Mr. Lee has put it strongly into context that it's really an interconnected global network. And the fact is that within the Caribbean, the cloud services are not anchored within the Caribbean. And as a result of which, we need to be mindful of the fact that our data is our own. But invariably, just like the tides in the ocean, it's going to flow through many different currents in many different jurisdictions. And that is our reality. Amelia, you had mentioned as part of your presentation, one of the key concepts of the GDPR is data protection as in design as a default, where your architecture is built such that it is kept in mind in terms of complying with our mandates. And Bartlett, you had brought into play the concept of data localization. Now, tying this together with the whole concept of a Caribbean cloud to facilitate data localization and the existence of local IXPs with that in mind, perhaps, Mr. Lee, you can take us through what would be the fundamental technical requirements that we would need to take into consideration to meet that concept of design data protection by design, and what would be sufficient to protect our data sovereignty.
All right, let me see if I could frame that simply and quickly. So I really did like that idea of by design. It's designed for privacy, for protection, and so on, because that does give the engineering side of things a particular structure, architecture to work with. It would involve things like if I am offering services in a particular jurisdiction, city, country, that there is redundancy and backup, double and triple somewhere inside of the design and considerations, as well as being able to transfer the data to somewhere else within that same jurisdiction. Right now, it's very convenient when we are setting up new services to back up large amounts of data to Amazon. That tends to be a lot of IT systems go to backup solution. We have Amazon and we have Microsoft and so on. And so there would have to be a very deliberate choice being made to establish contracts, relationships with data centers within the region, which can receive that data and store it long term. And this is where I think I like Bartlett's answer as well a few minutes ago when he says it depends. A lot of this is it depends on what we're willing to pay for and what we're willing to accept, because there certainly is software to do this. There certainly is storage, just like if we're just thinking about raw disk space, and there's knowledge that we have to be able to back up this way or transfer data between locations this way. These are things that we understand how to do. but I would also say it's not trivial. It doesn't have to be wildly expensive, but it's also not free. And so we have to kind of decide inside of the region, country by country, business by business, what are we willing to pay for now, and how do we kind of step by step get to where we want to go. I mentioned we have some pretty massive data centers in the region, BlueNap, what Cloud Carib is doing, but to get, and they do offer things like receiving offsite backup, and we can store your data long term, and we have real cloud services that will hold things locally. We actually have that, but they sunk millions of dollars into it to build those, and it took them a while to get there, which means the price point is going to be something that will allow them to recoup that. And that's at a completely different scale than some of the small, what we call micro data centers that we operate around internet exchange point, like the one in St. Lucia and Grenada and so on, which are low cost. And it's, I think in Grenada, in fact, local businesses, entrepreneurs are invited to host your website at the data center for free, right? But the scale of that is very different. It's supported by volunteer effort. It's subsidized by the regulator, and the protections and level of services that you get in that micro data center are at a different level and scale from the one that you get in Curacao. And none of them are illegitimate. It's just a matter of what can we afford and what does it take to get there over time. We have to always bear in mind the cloud that we consume today and the cloud that GDPR is helping to regulate and ensure the privacy of is something that took a while to get there. Right now, it's what everybody's using because it took a while to be built and it has now stabilized. And I guess every jurisdiction has this same challenge. Do I go with what already exists and cede to the policies and structures there, or do we take our time and do something which is more aligned to what we want to do here?
That's an excellent question and answer. And I must say, this would take me to one of the areas that is part of our theme for this panel in terms of information security. Leading on what you've just said, and also related to the general COVID context, there's a matter of BCP or business continuity, particularly when you'd mentioned the backup of data. Now, some of it is localized. Some jurisdictions choose to send it to a cloud environment that is hosted externally. But there's business vulnerability and then the backup of data. Given the fact that they're looking at a Caribbean cloud environment, what would be the best practice solution with regard to the backup of data to ensure BCP, particularly in times like these?
I'd say this, initially, well, where the infrastructure that we have right now, we do have, I think, operating at the scale in which it's possible in most countries to find some amount of hosting, let's call it that, that would allow us to operate servers which people can back up to and continue doing business remotely if they had to. I think we've gotten to the stage in which there's enough of that around the region. So immediately, in addition to the services that we can get from Amazon and Microsoft and Google, which are there and are certainly affordable, we do have some options inside of the region. And that's something I know businesses have been looking at. My customers who I talk to are looking at what do we need to do in our office to make this somewhere that we can continue to operate remotely and have some amount of continuity to the business, or if not at the office, what's available in country? Is there a small point of presence in country that we can rack a few servers and operate? So there are businesses are thinking more about, as we move out of the offices, or if we can't all congregate in the same way as we did before, can we virtualize our business? Unfortunately, well, fortunately, unfortunately, one of the easiest things to do, which a lot are opting to, is just purchase the services directly from the cloud providers, which immediately takes it out of the region. Microsoft 365, I'm sure, has seen a huge jump in licenses and so on, partly because persons like myself recommend to our customers, listen, you need to be able to use these services to continue business. Easiest thing to do is purchase a subscription and so on. And so businesses have been finding continuity. They have been finding new ways to keep the workflows going. But I can't say that it's a very comforting situation from a data privacy standpoint, because we've managed to have, I mean, because Microsoft and those companies are going to back up the data and it's going to be reliably held. So we do achieve the business continuity that we're looking for, but the price we're paying for it is some of that loss of jurisdictional control. But I don't think it's something that we're going to avoid in the short term.
I'd like to sincerely thank you, because you have succinctly contextualized your practical and business approach with regard to data management. And it's been equally balanced by the other members of the panel with regard to, okay, so you're backing up here, but this is really what is going to happen with regard to surveillance and security and legislative standpoint. And I'd like to thank every member of the panel this morning for their wonderful contributions. We are certainly all the better and more knowledgeable for it. And I'd like to give each of you the opportunity to make a closing remark or closing statement with regard to the area of data sovereignty, security, and privacy that you would like the audience to take away based on our discussions this morning. I can start with you, Bartlett. Yes.
Oh, thank you. So I will be brief, and I will say, listening to the other presenters and looking at the questions that came out and so on, I think what has become perhaps more apparent for me is that we do, in the region, from the perspective of government, certainly, and also, I guess, from citizens, there's more to be done. But certainly from the perspective of the governments, I believe that we now need to get to the practical aspects of contextualizing what we do around things like data privacy and data sovereignty and so on, around the larger big picture objectives, your digital strategies and so on. I think we need to think more clearly about how they fit together. And by extension, not just how they fit together, but also what are the implications for our citizens. It's nice to say you have, this privacy law on paper, but then when you go and check behind it, it's actually not in force, or it's in force, but no resources have been provided to actually enforce the law that is in force. And so these are the practical things that I think governments have to start thinking more seriously about. Are we passing laws around privacy and data security and so on for the sake of a checklist that says, well, we've done it, international donor, give us our aid? Or are we doing it because we truly want to foster an environment where, as we march into the digital age, our citizens feel empowered, they trust the different service offerings implicitly, and beyond that, they trust that there is a genuine recourse if something goes wrong. So I think these are some of the big picture considerations that we need to have within the region going forward. Thank you again.
Carlton Samuels.
I will just pass on, because Bartlett has pretty much said what I would have said. So,
Amelia.
Yeah, building on what Bartlett just said. So I think the Caribbean is yet to create a culture of privacy rights, but there's many benefits to be gained from developing better protection of privacy rights and the protection of personal data in the Caribbean. So it shouldn't be looked upon as a chore. There is great economic value in facilitating cross-border data flows. Obviously, strengthening individuals' privacy rights should be a key consideration. But it's also a data protection and data sharing framework can also be the backbone of effective digital governance. And in light of the COVID-19 pandemic, digital government has become all the more important. So the pandemic has only increased the impetus for Caribbean countries to put in place a strong data protection framework and also to create a culture of privacy protection and individual privacy rights in the region.
Mr. Lee?
Oh, thanks. So just want to end on a note that I think we've been making good progress in the area of developing the infrastructure inside of the region and our understanding of the issues. So I just want to continue to encourage ourselves and our governments to support and help to create the environment that will allow us to get where we want to in terms of sovereignty and privacy and rights for citizens. As we've been saying, there's not much value in having a law on the books where effectively as life plays out, it's not going to be effective to protect anyone. And so let's get the necessary components of the infrastructure in place. Encourage business, encourage entrepreneurs, encourage international cloud providers to help to improve the infrastructure in the region so that we can actually depend on it for the services that we want to consume.
I must say that I must express my sincere thanks and appreciation to the host of the Caribbean Internet Governance Forum in choosing the area of data sovereignty, security, and privacy for local online services, as this is an area that is quite significant and ever-growing importance within the Caribbean region. I can say that there are many interesting developments ahead of us as we continue with our data governance and data protection evolution. And I sincerely hope to see this on the agenda for the next governance forum. On that note, I would hand over to the Master of Ceremonies and also sincerely thank the excellent members of the panel this morning. Hats off to you, you've done a great job.
Thank you, Vashti.
Very much, Vashti and team. Excellent presentation. A very excellent approach to starting this panel and the entire day. So we do appreciate the comments and the interactions and the feedback and from the participants as well. So we will move to a break. We have a 15-minute break. Probably we will return around 10:57, thereabout, and we will resume with the second panel of the day. So thank you.